Have you ever wondered how giants of tech negotiate their contracts? Today on Tech Law Pro Academy, I'm going to give you insight into 4 ways that Google negotiates their agreements, plus a secret tip at the end that could really turn the tables in your favor. So let's just get right into it. The first tip is they negotiate on their papers. In layman's terms, this means using a contract that Google made and working with that as a starting point. To be frank, these agreements may initially seem overwhelming and they often won't fit in with your tech ecosystem. So you literally have to revamp, recarve the agreement to match your SaaS platform. But the key here when you're doing that is to fully understand your product. Because once you know what your product can do, and often more importantly, cannot do, you understand where you can be flexible. This also means you can communicate why certain adjustments to their standard contract are necessary for your SaaS platform. Let's say, for example, you have a platform that only ingests publicly available information. Then you would need to explain that you're unable to grant IP rights to the outputs from your SaaS platform. The reason? Your service only collects data available on the internet. Therefore, you can't grant what you don't have. Sounds simple, right? But while it's a fundamental aspect that should be plain as day, you're gonna need to communicate it to the other party. So you would need to remove any reference to ownership and reword it to instead provide perhaps a license to use that information during the term of the agreement. Tip number 2 revolves around using the customer's own data to provide the services. For example, let's say you're representing a SaaS company that monitors transactions to detect fraud. In order for your company to properly monitor those transactions, they will need to access the bank's complete transaction history. It's a lot of sensitive information. Companies like Google or major financial institutions, they have very strict provisions around the use of their data. So it's important to be able to explain to these big organizations why you'll need a bit more flexibility around the use of their data in order to provide the services. Tip number 3 deals with how much money your customer can sue you for if your company breaches an obligation. Big players like Google don't cap their direct damages. So this means that you will take a hit for all actual losses. If things go south, like a data breach, as a vendor, you would face unlimited financial exposure. And this is extremely risky if you're a SaaS vendor. But as a customer, this is a great strategy because it can protect the customer from potentially all direct harm. For customers, it's a protective measure, ensuring full recovery from any mishap, kind of like an insurance policy. But unless you're representing Geico, your client is not an insurance company. And if you allow an unlimited cap on direct damages, one mistake can put you out of business. Let's take a quick look at this chart. This breaks down the differences between direct damages and indirect damages. You will have some provisions discussing incidental damages, but the main ones are direct and indirect, also known as consequential. So direct damages are the immediate, obvious losses that are caused by the breach, like repairing the cost directly related to it, any lost revenue that you suffered that's directly related to the breach. Indirect damages, also called the consequential damages, these are the secondary losses that kind of result from the breach, but they're not immediately tied to it. So missed business opportunities, things like that. These special types of different circumstances that are unique to each business. The 4th tip, and this is a big one, intellectual property. Google and other large companies rarely allow the use of their logo. There is a high importance on securing their IP rights in negotiations. If you're a startup, if you're representing a startup and you're the attorney, this is super problematic. You need to be able to display that you have a giant company as your customer. Including Google's logo can add major social proof to your company. So you'll want to work with Google to set up approval guidelines around the use of their logo. You can add language that your company will ask Google for Google's permission for each use of their logo and how your company will adhere to Google's guidelines around the use of their logo. So here's an example to help you out. I'll also put a link in the description so you can get a copy of my most used provisions in MSAs. Now for the bonus tip. This can really tip the scales in your favor. What you need to do is always try to supplement the MSA with your templates. So when you're working with these huge giants, you're never going to get them to negotiate off of your paper. But what you can get is for them to attach maybe your DPA, maybe your security provisions as an addendum or an exhibit to the contract. I always advise you to push to attach your own DPA, also referred to as a data processing addendum. This is because your DPA is tailored for your platform. And so this shouldn't be too difficult of an ask. The whole entire DPA hinges on one definition that most attorneys get wrong. And if you make this mistake, it can result in millions of dollars in fines. And in this video, I tell you exactly what you need to look out for so you don't get the short end of the stick. Thank you for tuning in, and I'll see you in the next video.